Hello and welcome to this training on the Family Unity Parole in Place program for legal service providers and pro bono response. My name is Dina Sharouk, and I'm a senior legal advisor to the American Bar Association's Commission on Immigration, and I'm joined today by my colleague, Emily McCabe.
Thanks, Dina. My name is Emily McCabe, and I'm pro bono counsel at the ABA Commission on Immigration.
The goal of this training is to orient you to this new program so that your staff or volunteers can screen callers to see if they have the basic eligibility for immigration benefits. If they do, we suggest providing callers with basic information on how they can prepare for the application process, as well as provide them with referrals for group processing events or lists of reputable providers in their area. We will also discuss strategies and models for legal service providers to scale up services to meet the needs of individuals who could benefit from group processing. The contents of this video are not legal advice. It's important to note that on August 26, 2024, the U.S. District Court in the Eastern District of Texas issued a stay preventing the Department of Homeland Security from granting parole in place applications for 14 days. During this time, USCIS can continue to receive applications. If you choose to serve applicants during this period, you should explain the implications of this stay, and applicants should give their informed consent before you continue to help them with their applications. Here's what we're going to cover today. We'll talk about the new Parole in Place program, what it does and who qualifies. We'll talk about how an eligible applicant can prepare for the application process. We'll provide you with a sample script and screening template, as well as tips for screening callers. Finally, we'll discuss various pro bono models that may assist legal service providers in triaging and scaling up services to meet the needs of their communities. Let's begin by talking about the new Parole in Place program. In June of 2024, the Biden administration announced that they would be creating a new Family Unity Parole in Place program to keep together families with mixed immigration status, meaning some family members have permission to be in the United States while others don't. By giving these members of the family a pathway to legal immigration status, some mixed families won't have to live in fear of a family member being arrested by immigration enforcement and/or deported. Parole in Place lets eligible individuals who are in the country without immigration status apply to receive immigration benefits, such as employment authorization and legal permanent residence, also referred to as a green card. With Parole in Place, an applicant can apply for these benefits without having to leave the country. If one is granted parole in place, they are treated as if they entered the country with permission, and they are permitted to apply for a new immigration status. In most cases, folks who enter the United States without permission cannot receive immigration benefits until they leave the country with permission so that they can be processed by a consulate, although there are some exceptions. Generally, individuals who have to leave the country need to seek a waiver showing extreme hardship to a U.S. citizen or legal permanent resident spouse or parent. Processing for this waiver with USCIS and then at the consulate can take several years. During processing, these individuals are not eligible for any benefits such as work authorization. So who qualifies? The family members that qualify are individuals who are spouses of U.S. citizens or stepchildren of U.S. citizens. Each individual has to meet a certain list of qualifications to be eligible. For spouses of U.S. citizens to qualify, they have to have a legally valid marriage to a U.S. citizen on or before June 17, 2024. They also must be present in the United States without parole or admission. That means that they entered the United States without permission. As a note, spouses of U.S. citizens who entered the United States with a visa or parole may already be eligible to adjust status without leaving the United States. The spouse must have been in the United States continuously since at least June 17, 2014, and through the date of filing the request for parole. The spouse must not have any disqualifying criminal history or be considered a threat to public safety or national security. And finally, the spouse must merit parole in place as a matter of discretion. For stepchildren of U.S. citizens, they also have to be unmarried, have been under the age of 21 on June 17, 2024, been present in the United States without parole. Again, that means that they entered the U.S. without permission. They had to have been present in the United States since June 17, 2024, be the stepchild of a U.S. citizen, meaning a valid marriage between the stepparent and non citizen occurred before the stepchild turned 18 years old. Also, the marriage between their non citizen parent and the U.S. citizen stepparent must have been legally valid and entered into on or before June 17, 2024. The stepchild must not have any disqualifying criminal history or could be considered a threat to public safety or national security. And finally, they must merit parole in place as a matter of discretion. It is important to note that meeting the requirements for parole in place under this process does not establish eligibility for other immigration benefits, including legal permanent resident status. If approved, the parole status is valid for up to 3 years. If someone applies and gets parole in place through this program, they should apply for legal permanent residence within 3 years, and in the interim, the individual will be eligible to apply for work authorization based on C-11 parole after the parole is approved. What can folks do if they are eligible? The application for Family Unity Parole in Place is available on the MyUSCIS website. The application is only available online, and all evidence must be digitized and uploaded. Applicants must create or use their MyUSCIS account to access the application, whether they file with or without an attorney. In order to create a MyUSCIS account, one must have an email address. Applicants will have to submit evidence to prove that they qualify for parole in place. All documents that will be submitted with an application should be a copy and not an original. Also, any documents that are not in English will have to be submitted with an English translation. The person who does the English translation will have to swear that they have the ability to translate the document from the document's language into English. They can do this by filling out a certificate of translation and attaching it to the document translated. Certificate of Translation forms can be found in the appendix of the Executive Office for Immigration Review's guidebook. Here is an example of a certificate of translation. The translator shouldn't be the applicant or someone related to the applicant. Callers who qualify can prepare by making copies of evidence that they qualify for parole in place and, if necessary, having them translated into English as soon as possible. Spouses of U.S. citizens will have to prove that they are married to a U.S. citizen and that they got married on or before June 17, 2014. To do that, they should obtain a copy of their marriage certificate. They should also make a copy of a document proving their U.S. citizen spouse's citizenship. This could be a U.S. birth certificate, a U.S. passport, or a copy of a certificate of naturalization. For U.S. citizen stepchildren, they should collect the same documents as well as provide their own birth certificate to show that they are the biological child of the non-U.S. citizen spouse. That birth certificate should also prove that the stepchild was under the age of 21 on June 17, 2024. Stepchildren do not need participation of either parent to apply. To prove continuous presence for 10 or more years, spouses of U.S. citizens will have to collect any documents that show that they have been in the United States during that period to the time of filing. This can include lease agreements, rent checks, utility bills, bank statements, medical records, birth certificates of children, and school records as just a few examples. Applicants should aim to find a record covering their whole time in the United States. We recommend trying to find at least one record for each quarter or 3 months in the United States. We recommend cataloging these items in a chart to keep track of them. Here's an example of how you can document and catalog pieces of evidence. Note that evidence from 2014 must be on or before June 17. It is best practice to organize evidence in chronological order. For stepchildren, they only need to show continuous presence in the United States since June 17, 2024. In this case, we recommend collecting and submitting a record for each month from June 2024 to the month of filing. Both spouses and stepchildren of United States citizens will have to show that they entered the United States without permission. To do that, they should collect their passports from the time that they entered the United States until the present. They should copy all pages of the passport. This will show that there are no entry stamps to the United States during the time that they entered and remained in the United States. With respect to criminal history, there are a few things to note. First, all pending criminal charges are disqualifying, regardless of the nature of the charges. You must wait to apply for parole in place until those charges are resolved. Second, all felony charges are disqualifying, even if they are expunged or pardoned. A felony is a federal, state, or local criminal offense punishable by imprisonment for a term exceeding 1 year. Third, all other criminal convictions, excluding minor traffic offenses and including juvenile delinquency adjudications, will result in a rebuttable presumption of ineligibility. Applicants who have been convicted of or have even been arrested for a crime should collect all records that they have regarding any criminal incidents. They will need to have an attorney review those records to see if they are still considered eligible. Let's talk now about how volunteers can screen potential applicants for eligibility for the Parole in Place program using an online form. Up front, it's important that individuals who are not immigration attorneys or immigration practitioners not provide any of the callers with legal advice. That's important because we don't want to mislead any of the callers and we don't want to give them any advice that could harm them going forward. If you are a lawyer, you should make clear that you are not the caller's lawyer, nor are you representing them in this case. Let's talk now about what happens when a potential applicant calls in. When callers connect, introduce yourself, offer a little bit of information about the program, and then go through a series of questions with the applicant, screening them for eligibility. We have created a screening form for your usage in screening applicants. That screening form is available at this QR code on the screen. For a template of this screening form for your organization's use, you can also use the QR code listed here to modify for your needs. Depending on how an applicant answers a question, the form will provide the volunteer with information to provide the caller. Once the volunteer has collected information and provided relevant information, volunteers should send eligible applicants a list of pro bono and low-cost attorneys in their area. They should also send a copy of the information the caller provided so that the caller may provide that same information to an attorney. The script for the form can be found in the Family Unity Parole in Place Legal Clinic Toolkit. You can see the QR code linking to the toolkit and script here. Here are some tips for screeners. Screeners will be asking callers sensitive and personal questions in order to deduce their eligibility for the program. It's important for the volunteers to make their role clear to the callers. Remind the caller that the information they provide will stay within your organization and that the caller can end the conversation whenever they choose. If an applicant asks a question about the process to which the volunteer does not know the answer, they should take down the question and offer to look into it for the caller. Volunteers should follow up with the caller either by phone or email once they have collected the answer. The script provides language that both orients the caller and gives them the opportunity to withdraw from the phone call if at any time they wish to do so. The script and form provide volunteers with questions they will pose to callers. If a caller provides an answer that renders them ineligible for the program, the form will prompt the screener to inform the caller and provide them with the language to do so. Similarly, if the caller provides answers that make them eligible for the program, the form and script provide language to provide the caller with their next steps.
Next, we will discuss pro bono models. Group processing models. Once individuals are triaged based on financial need and eligibility, only individuals with clear eligibility should be referred into any group processing model. It is best practice to have referrals for legal service providers, pro bono or low bono attorneys, and private attorneys ready based on need, and to try and reserve the extra resources for the more complicated cases. Providers should also review existing clients in removal proceedings or with pending or prospective 601 waivers for eligibility. There are several creative models to consider, but the type we will focus on today for parole in place is the legal clinic model. The legal clinic model represents a successful and sustainable creative model for serving a large number of applicants with limited resources. This creative model is highly adaptable to changing needs of the impacted community and to the space and time convenient to those involved. Legal clinics can be virtual, in person, or hybrid and have been employed for years by many legal organizations. They are frequently used for discrete, time sensitive cases that affect large numbers of people. Legal clinics are designed to provide competent legal assistance while empowering the applicant. The clinic volunteers or staff educate applicants seeking services and help them complete the form on a limited scope basis, which generally starts and ends at the legal clinic. It is also an option for clinics to occur as part of representation, which streamlines the application process for those involved. Legal clinics can involve community members who want to assist but are not attorneys, but be mindful to have quality control and extensive oversight conducted by expert immigration attorneys. Community institutions can assist by providing space, food, and/or access to technology for participants. One of the first decisions to make when building a legal clinic is whether it will be held virtually, in person, or in a hybrid format. The right format for the clinic will depend on the needs of the volunteers, staff, and applicants, while also considering the resources available to the legal service provider. For a detailed list of relevant considerations, please see our Family Unity Parole in Place Toolkit. Parole in Place applications are only available online. This necessitates a MyUSCIS account for at least the participant. You may consider having a standalone clinic to create the MyUSCIS account and/or email for potential applicants. In past ABA Commission on Immigration virtual pro se legal clinics, we have used Zoom to screen share and request control of the screen when the applicant is logged into their MyUSCIS account, and then proceed to fill out the form together. If the applicants are clients, the volunteers or staff attorneys can use their attorney MyUSCIS account, fill out the form together, and then link the cases on MyUSCIS through a verification code sent to the email of the applicant. The details of creating and utilizing the applicant's MyUSCIS account are important considerations in a clinic setting and are discussed in detail in our toolkit. The starring roles in a legal clinic are the legal captains, tech captains, and form preparers. Legal captains are experienced immigration attorney volunteers or experienced staff. Legal captains are available throughout the clinic to answer questions that arise during the applicant's appointments. Legal captains are also required to review each parole application and accompanying evidence before the appointment ends. Tech captains are volunteers or staff that help with the logistics of the clinic and ensure a smooth experience for everyone. Tech captains may help with the planning of the clinic and assist during the clinic with any technological or logistic issues that arise. They will not work directly with applicants on their forms. Form preparers are attorneys or non-attorney volunteers who meet with the applicant during the clinic to help them complete their application and help them decide what accompanying evidence to include. Other folks that may be helpful or necessary include pre-screeners and interpreters. It is imperative to train your volunteers and support them throughout the clinic. Remember, happy volunteers return and repeat volunteers make your job much easier. The flow of a legal clinic is fast, so it is important to stay organized and to have completed all the pre-clinic tasks beforehand to ensure a smooth experience. For information including samples and templates to stay organized, please see our Family Unity Parole in Place Toolkit. The day of the legal clinic, legal captains and tech captains do last-minute technology checks before opening the doors, literally or virtually. Then the form preparers arrive and a legal captain gives a quick refresher training on key points learned in their pre-clinic training. Form preparers are then sent to their rooms, literally or virtually. And next, the applicants arrive for their designated appointment slots, and a legal captain provides a short introduction to the clinic. Meanwhile, a legal or tech captain matches the form preparers with applicants. Then, the applicants are sent to their corresponding rooms where the form preparer is waiting. Form preparers work with the applicants on the Form I-131F. Legal captains are circulating throughout the clinic and also wait in the main room along with tech captains to be called in the event of a question or issue. Before the form is finalized, the form preparer summons a legal captain for a legal review. The legal review is as simple as scrolling through the form on the applicant's MyUSIS account, verifying information, checking for inconsistencies, and double-checking the supporting evidence. If the form looks good, the legal captain will provide further instructions to both the applicant and form preparer on the preparer signature page and submission. After the form is submitted, or in the event that the form is not ultimately submitted, the form preparer fills out the exit form and explains the next steps to the applicant. After the clinic is completed, legal captains will review the exit forms and see if there is any direct follow-up necessary, such as signing the applicant up for the next clinic so they have more time to gather evidence or fees, or referring a complicated case to local pro bono or low bono immigration attorneys. Additionally, a legal or tech captain will reiterate next steps information via email to the applicants. Form preparers and applicants will also receive a thank you for participating email. Thank you for watching this video brought to you by the American Bar Association's Commission on Immigration. If you have any questions regarding this video, please reach out to us at the Commission on Immigration at imcenter@americanbar.org. Thank you and be well.